On the morning of March 14, 2023, a routine parliamentary hearing was about to become one of the most controversial incidents in modern judicial history. Inside Courtroom 7 of the Central Criminal Court, lawyers shuffled papers, journalists settled into their seats, and a respected member of parliament prepared to testify. What happened in the next 90 seconds would spark national outrage, trigger an international human rights investigation, and force an entire nation to confront uncomfortable questions about power, race, and accountability within its justice system. A police officer, sworn to protect and serve, would strike a sitting member of parliament. Moments later, that officer would collapse, unconscious. But this isn't a story about violence. It's a story about what happens when systems fail, when authority is abused, and when the mechanisms designed to protect justice become the very instruments that threaten it. This is the story of David Mensah, a black member of parliament who walked into a courtroom to defend his integrity, and walked out having witnessed the collapse of another human being, even as his own dignity was assaulted. To understand what happened that day, we need to understand who David Mensah was and why he was in that courtroom. David Mensah was born in 1978 in the diverse borough of Lewisham, South London, to Ghanaian immigrant parents who had come to Britain in search of opportunity. His father worked night shifts as a hospital porter. His mother cleaned offices in the financial district. They instilled in young David a fierce belief in education, hard work, and public service. Mensah excelled academically, earning a scholarship to study politics, philosophy, and economics at Oxford University. But he never forgot where he came from. During university holidays, he volunteered at youth centers in his home borough, mentoring young people from backgrounds similar to his own. After graduating, Mensah could have pursued lucrative careers in law or finance. Instead, he became a community organizer, working on housing rights and police accountability issues. Those who knew him during this period describe a man who listened more than he spoke, who built coalitions across racial and class lines, and who genuinely believed that the system could work for everyone if the right people fought to make it so. In 2010, at the age of 32, David Mensah was elected to Parliament, representing his home constituency. He was one of the youngest MPs in that election cycle, and one of only a handful of black representatives in a chamber that remained overwhelmingly white. Over the next 13 years, Mensah built a reputation as a principled but pragmatic politician. He championed affordable housing legislation, pushed for reforms in police training and accountability, and served on multiple committees dealing with justice and equality issues. He wasn't the loudest voice in Parliament, but he was often the most effective. Colleagues across party lines respected him. One Conservative MP later said, "You might disagree with David on policy, but you could never question his integrity or his commitment to his constituents." By 2023, Mensah was being discussed as a potential future minister. His approval ratings in his constituency were among the highest in the country. He had built something rare in modern politics: genuine trust. But politics is a contact sport, and success breeds scrutiny. In January 2023, a political storm erupted that would threaten everything Mensah had built. An investigative journalism outlet published allegations that Mensah had improperly used his parliamentary office to benefit a local business owned by his cousin. The allegations suggested that Mensah had written letters of support and made introductions to government officials that helped secure contracts worth hundreds of thousands of pounds. The story was explosive. It combined familiar elements that always generate headlines: a rising political star, family connections, potential corruption, and money. Mensah immediately and categorically denied the allegations. Within hours of publication, he released a detailed statement. He acknowledged that his cousin owned a business in his constituency, and that his office had indeed provided standard constituent services, including letters of introduction that his office provided to dozens of businesses and organizations every year. But he insisted that every action had been above board, transparent, and consistent with parliamentary rules. He had not personally benefited financially. He had not used his position to give his cousin any special treatment beyond what any constituent could expect. "I have nothing to hide," Mensah said in a press conference that afternoon, his voice steady but his face showing the strain. "I welcome any investigation. My record speaks for itself." The Parliamentary Standards Committee opened a formal inquiry. So did the police, investigating potential violations of anti-corruption statutes. For someone who had built their career on integrity, the accusations were devastating, even if he believed he could prove his innocence. The investigation dragged on for weeks, then months. Every detail of Mensah's finances, correspondence, and family relationships was scrutinized. The media coverage was relentless. Some outlets were measured and factual. Others were less careful, with headlines that implied guilt before any evidence had been presented. Mensah's allies noticed the pattern. While white MPs caught in similar or more serious scandals often received more measured coverage and were given the benefit of the doubt, Mensah seemed to face a harsher spotlight. The subtext wasn't always explicit, but it was there. Questions about whether he truly belonged in Parliament. Suggestions that his rise had been too fast. Implications that perhaps he wasn't as trustworthy as he seemed. By March, the parliamentary investigation had found insufficient evidence of wrongdoing. The police investigation, however, continued. That's what brought Mensah to the courthouse on March 14th. Not as a defendant, but as a witness in a related hearing about the investigation's conduct. He was there to testify about the scope of the investigation, and to challenge what his lawyers argued were overreach and procedural violations in how evidence had been gathered. It should have been a routine appearance, a few hours of testimony, some legal arguments, and home by evening. Instead, it became a day that would change everything. Courtroom 7 of the Central Criminal Court is not a grand chamber. It's a modern, functional space with wood paneling, fluorescent lighting, and rows of benches for lawyers and observers. On the morning of March 14th, it was about half full. Mensah arrived early, dressed in a dark suit and tie. Witnesses later described him as calm and composed, though the strain of months under investigation showed in his face. He greeted his legal team, reviewed some documents, and took his seat. The hearing was scheduled to start at 10 a.m. Judge Patricia Harrison, a 62-year-old jurist with a reputation for fairness and efficiency, presided. The prosecution was represented by a team from the Crown Prosecution Service. Mensah's defense team consisted of 2 barristers and a solicitor. Also present, a handful of journalists, some members of the public who had secured seats, and 4 police officers providing courtroom security. This was standard protocol for any hearing involving a public figure or sensitive investigation. One of those officers was Sergeant Colin Turner, a 28-year veteran of the Metropolitan Police. Turner had worked courtroom security for 5 years. His record was unremarkable: a few commendations for long service, no serious disciplinary issues. Colleagues described him as quiet, professional, and generally competent at his job. Turner's role that day was simple: maintain order, ensure security, and respond to the judge's directions. It was a job he had done hundreds of times. The hearing began on schedule. For the first 90 minutes, it proceeded without incident. Lawyers presented arguments about evidence-gathering procedures. The judge asked questions. Mensah listened, occasionally conferring with his attorneys. Just before 11:30 a.m., Mensah was called to provide testimony. He stood, moved to the witness stand, and was sworn in. He confirmed his name and his position as a member of Parliament. The prosecution began their questioning. Their tone was professional but pointed, probing the details of Mensah's relationship with his cousin, the timeline of various letters and meetings, the nature of constituent services his office provided. Mensah answered carefully and thoroughly. He maintained eye contact. He didn't become defensive or evasive. Those watching said he seemed like someone confident in the truth of his statements. Then, about 20 minutes into his testimony, something shifted. One of the prosecutors asked a question about a specific letter Mensah had written. Mensah began to answer, but the prosecutor interrupted, suggesting that Mensah was not being fully forthcoming. Mensah's attorney objected. The judge sustained the objection and instructed the prosecutor to rephrase. The prosecutor's next question carried an edge, an implication. Mensah's response was firm, not angry, but clear that he felt the question was unfair and mischaracterized his actions. The exchange wasn't heated exactly, but the temperature in the room had changed. The casual observer might not have noticed, but those familiar with courtroom dynamics could feel it. A moment where civility strained against underlying tension. What happened next is documented in multiple sources: witness testimony, court transcripts, and security camera footage that, while silent, captured the physical sequence of events. The prosecutor pressed on with another question. Before Mensah could answer fully, the prosecutor interrupted again, suggesting Mensah was being evasive. Mensah's attorney stood to object. Judge Harrison held up her hand, signaling a pause. "I think we need to take a brief recess," Judge Harrison said, her tone measured but firm. She could sense the tension escalating, and wanted to diffuse it before it worsened. But as she spoke, Mensah did something that, in retrospect, was entirely ordinary, but would be characterized very differently by different observers. He shifted his weight, turned slightly toward his attorney, and made a small gesture with his hand, possibly frustration, possibly just emphasis, as he said something quietly. From his position 15 feet away, Sergeant Turner apparently interpreted this as something else. What exactly he thought he saw, we still don't know with certainty. His later statements were confused and contradictory. But in that moment, Turner moved. He stepped forward quickly, not running, but moving with purpose. Multiple witnesses reported that he said something, though accounts differ on what. Some heard "don't move." Others heard "stop that." Some heard nothing clearly. And then, in an action that shocked everyone present, he struck Mensah on the upper arm and shoulder. A quick, forceful blow designed to restrain or control. Mensah, who had not been expecting any physical contact, jerked backward. His elbow struck the edge of the witness stand. He stumbled, but did not fall. The courtroom erupted. Mensah's attorneys jumped up, shouting. The judge called out, "Officer, stand down." The other police officers in the room moved forward, uncertain whether to restrain their colleague or assist him. Mensah himself seemed more stunned than injured. He raised his hands in a universal gesture of non-aggression, taking a step back from Turner. Turner, for his part, seemed to realize immediately that he had made a catastrophic error in judgment. His face, captured on the security footage, showed confusion and something close to panic. He took a step back, then another. His hand went to his chest. His other hand reached out to steady himself on a nearby table, but he missed it. And then, in front of 50 witnesses, Sergeant Colin Turner collapsed. The sound of his body hitting the floor silenced the courtroom instantly. Pause. Silence for 3 seconds. For a moment, no one moved. The human brain needs time to process the unexpected. What had just been a chaotic scene of professional protest and judicial confusion had transformed into a medical emergency. One of the other officers was the first to react, rushing to Turner's side and calling for medical assistance. A court clerk grabbed a phone, Someone in the gallery, a doctor who happened to be attending as an observer, pushed through and began assessing Turner's condition. Turner was unconscious, but breathing. The doctor checked his pulse, rapid and irregular. Turner's skin was pale, sweating, classic signs of a cardiac event. In the meantime, the doctor and the other officers began basic first aid. Judge Harrison cleared the courtroom, ordering everyone except essential personnel to leave immediately. Mensah stood frozen at the witness stand, his own attorney gripping his arm. Later, witnesses would report that Mensah looked stricken, not triumphant or vindicated, but genuinely horrified at what was unfolding. The ambulance arrived within 8 minutes. Paramedics stabilized Turner and rushed him to the hospital. Initial assessments suggested he had suffered a cardiac episode, possibly a heart attack or severe panic attack triggered by the stress of the moment. By 11:52 a.m., less than 30 minutes after the hearing had seemed routine, courtroom 7 was empty, except for the judge, a few officials, and the lingering awareness that something unprecedented had occurred. Judge Harrison adjourned the hearing indefinitely. She ordered the security footage preserved and requested immediate reports from all officers present. David Mensah left the courthouse through a back entrance, surrounded by his legal team and additional security. He declined to speak to the waiting journalists. His attorney read a brief statement expressing concern for Sergeant Turner's health and promising full cooperation with any investigation into the incident. By noon, the first news alerts were pinging across smartphones throughout the country. By 1 p.m., the video footage had leaked. By evening, it was international news. The leaked footage spread across social media within hours, viewed millions of times before the sun set on March 14th. The silent security camera video showed the entire sequence. Mensah testifying, the gesture, Turner advancing, the strike, Mensah's reaction, and Turner's collapse. Without audio, viewers could project their own interpretations onto the footage. And they did. The response divided along predictable but painful lines. For many, particularly in black and minority communities and among Mensah supporters, the footage confirmed their worst fears about how power operates in Britain's institutions. Here was a member of Parliament, performing his civic duty, struck by a police officer for no apparent reason. The optics were damning. A white officer using force against a black MP in a courtroom, a space that should embody justice and equal treatment under law. This is what we mean when we talk about institutional racism, wrote one prominent civil rights activist. David Mensah had every right to be in that courtroom. He had committed no crime. He posed no threat. Yet a police officer felt entitled to put hands on him. This is about power, and who is assumed to have it. Protests erupted in Mensah's constituency that evening. Hundreds gathered outside the local police station, carrying signs reading, "Protect MPs, don't attack them," and "Justice for David Mensah." The demonstrations were peaceful but passionate. Speakers drew connections between this incident and broader patterns of police interactions with Black Britons. But not everyone saw it the same way. Some defended Turner, or at least counseled caution before rushing to judgment. They pointed out that courtroom security officers operate under enormous pressure, that split-second decisions are required, and that we shouldn't condemn someone before understanding their perspective. "We don't know what Turner saw or thought he saw," wrote one police union representative. "Officers are trained to respond to potential threats. Until we know what he was responding to, we shouldn't assume the worst about his intentions." Others went further, suggesting that Mensah himself bore some responsibility for the confrontation. Conservative commentators pointed to Mensah's gesture in the footage, arguing it could have appeared threatening. Some questioned why Mensah was gesticulating in court. Others suggested the entire incident was being weaponized for political purposes. This division played out in media coverage that often reflected existing political and social fault lines. Progressive outlets led with headlines about a police attack on black MP. Conservative papers were more circumspect. Officer collapses after courtroom incident, or MP hearing ends in medical emergency. The social media discourse was even more polarized. Hashtags like Justice for Mensah and Defend Turner both trended simultaneously. Activists shared the footage alongside data on racial disparities in police use of force. Counter-protesters shared statistics on attacks on police officers and argued for presumption of innocence. The intensity of the response revealed something deeper than just this single incident. It tapped into accumulated frustrations, fears, and beliefs about race, justice, and power that had been building for decades. Mensah himself remained largely silent for the first 48 hours. His office released only brief statements confirming he was uninjured and expressing hope for Turner's recovery. This restraint was strategic. His attorneys knew that anything he said would be scrutinized and potentially weaponized, but it also seemed genuine. Those close to Mensah said he was deeply shaken by the entire experience. Turner, meanwhile, remained in hospital. Initial reports suggested he had suffered a significant cardiac event brought on by acute stress. He was stable, but would require ongoing treatment and monitoring. His family requested privacy, and the hospital complied. 3 days after the incident, the Independent Office for Police Conduct, IOPC, announced it would conduct a full investigation. The Metropolitan Police suspended Turner pending the outcome. Parliamentary authorities opened their own inquiry into courtroom security protocols. And David Mensah, after consulting with his advisors and his family, decided to speak publicly. On March 17th, David Mensah gave his first television interview since the incident. He chose to speak with a respected veteran broadcaster known for fair, substantive journalism, rather than sensationalism. Mensah appeared composed, but visibly affected by the previous days. He spoke carefully, choosing his words with precision. "I want to be clear about several things," he began. "First, I hope for Sergeant Turner's full recovery. Whatever happened in that courtroom, I don't wish him harm. He's a human being, and he deserves medical care and support. Second, I don't believe Sergeant Turner is a bad person. I think he made a terrible error in judgment. But that error didn't happen in a vacuum. It happened within systems and structures that we need to examine honestly. I was struck by a police officer while giving testimony in a courtroom. I had done nothing threatening. I had done nothing to provoke physical intervention. Yet, an officer felt empowered to use force against a sitting member of Parliament. We have to ask, would that have happened if I were white? Would that same gesture have been interpreted as threatening? Would that same level of force have been used?" The interviewer pressed, "Was he claiming racism?" "I'm saying we need to be honest about implicit bias and how it operates," Mensah responded. "Sergeant Turner may not consciously harbor racist beliefs, but we all carry unconscious assumptions shaped by the culture we live in. Research consistently shows that black men's actions are more likely to be perceived as threatening, even when they're identical to white men's actions. That's not about individual malice, it's about systemic patterns." The interview was widely shared and generally well received, even by many who had been skeptical of Mensah. His refusal to demonize Turner while still addressing structural issues struck many as measured and principled. But the legal implications remained complex. From a criminal standpoint, the question was whether Turner had committed assault. Under UK law, assault doesn't require intent to harm, only an intentional act that causes another person to apprehend immediate unlawful violence. Turner had struck Mensah without legal justification. The defense would likely argue that Turner genuinely believed he was responding to a threat, which could mitigate or excuse his actions. Parliamentary privilege added another layer. Members of Parliament enjoy certain protections designed to allow them to perform their duties without harassment or obstruction. An attack on an MP, even unintentional, raises constitutional questions about parliamentary independence. Civil liability was also at stake. Mensah could potentially sue both Turner personally and the Metropolitan Police for assault, constitutional violations, and damages. The police force could face institutional liability for inadequate training or supervision. Beyond individual liability, the incident raised urgent questions about courtroom security protocols. How are security officers trained to assess threats? What oversight exists for their actions? What recourse do witnesses and defendants have if they believe security officers are acting improperly? A parliamentary committee convened emergency hearings to examine these questions. They heard from policing experts, civil rights advocates, legal scholars, and current and former judges. The picture that emerged was troubling. While courtroom security officers received basic training, there appeared to be significant gaps in de-escalation techniques, implicit bias awareness, and accountability mechanisms. Officers had broad discretion to use force with relatively little oversight. Several experts testified that Turner's actions, while extreme, reflected broader patterns of how authority operates in British institutions. Patterns where some individuals are afforded more presumption of respect and non-threat than others. Judge Harrison, who had presided over the hearing, was called to testify about her observations. She was measured but clear. In 30 years on the bench, I have never seen an officer use physical force against a witness or party who was simply standing and speaking. Mr. Mensah posed no threat whatsoever. The use of force was entirely unjustified. The Metropolitan Police Commissioner appeared before the committee and committed to reviewing training protocols and accountability measures. He acknowledged that implicit bias is real and we must address it, while defending the broader professionalism of his force. But for many observers, these institutional processes felt inadequate to the scale of what had happened. A member of Parliament had been struck in court. The democratic function itself had been violated. Words about reviewing protocols seemed insufficient. 3 months after the incident, the IOPC completed its investigation. Its findings were detailed and damning. The report concluded that Sergeant Turner had used unlawful force against David Mensah without justification. Mensah's gesture, a simple hand movement, posed no credible threat. Turner had misinterpreted or overreacted to ordinary behavior. The report found no evidence that Turner acted from conscious racial animus, but it noted that implicit bias likely influenced his threat assessment. The report recommended that Turner face gross misconduct proceedings and possible criminal charges. It also recommended systemic reforms, including mandatory implicit bias training, stricter protocols for use of force in courtrooms, and enhanced oversight of security personnel. Turner was ultimately dismissed from the Metropolitan Police. The Crown Prosecution Service decided not to pursue criminal charges, determining that while Turner's actions were unjustified, they did not meet the threshold for criminal assault, given the complex circumstances and his evident immediate regret. Turner issued a public apology through his attorney. He acknowledged that his actions were wrong and that he had let down his profession. He expressed particular remorse for the trauma caused to Mensah. He also revealed that the stress of the incident and its aftermath had exacerbated underlying health conditions that had previously been undiagnosed. Mensah accepted the apology, but emphasized that individual accountability was insufficient. "This isn't just about one officer's mistake," he said in a statement. "It's about systems that enable those mistakes and that burden particular communities with their consequences." The original investigation into Mensah's alleged corruption concluded 2 months later. The police found no evidence of wrongdoing. The parliamentary committee similarly cleared him. The allegations that had consumed months of his life and brought him to that courtroom were unfounded. Mensah returned to his parliamentary duties, but the experience had changed him. Friends said he was more cautious, more aware of how precarious even established position and reputation could be. The incident did produce tangible reforms. Parliament passed new guidelines for courtroom security. The Metropolitan Police implemented the IOPC's training recommendations. Several judges began advocating for independent oversight of courtroom security decisions. But the deeper questions remained unresolved. What does it mean when someone can hold high office and still have their fundamental dignity and safety questioned? How do we build institutions that genuinely provide equal protection and respect to everyone, regardless of race or background? The courtroom incident of March 14, 2023, lasted less than 2 minutes. But its implications continue to resonate. David Mensah remains in Parliament, continuing to serve his constituents and advocate for justice reform. He has become an even more prominent voice on issues of institutional accountability, though he insists he never wanted this platform. Sergeant Colin Turner left policing and largely withdrew from public life. He has reportedly undergone extensive counseling and has spoken privately about his regrets. The courtroom where it happened looks unchanged. Cases proceed. Witnesses testify. Security officers maintain order, now operating under slightly different protocols, with slightly more training, with slightly more awareness. Whether these changes are sufficient, whether they address the root causes that allowed that moment to occur, remains an open question. What is certain is this: the incident forced a national conversation about assumptions, power, and justice that many would have preferred to avoid. It revealed the gap between the ideal of equal treatment under law and the reality of how institutions operate. And it reminded us that sometimes the most important moments are not the ones carefully planned or orchestrated, but the unscripted seconds when systems either uphold their stated values or reveal their failures. Justice, in the end, is not just about laws written or verdicts delivered. It's about the thousands of small interactions where respect and dignity are either granted or denied, where assumptions are either challenged or reinforced, where power is either checked or allowed to operate unchallenged. The question facing any society that values justice is not whether incidents like this will occur. Human institutions will always be imperfect. The question is what we do afterward. Whether we learn, whether we change, whether we build systems worthy of the principles we claim to hold.